Tonight we're going to be very ethical. We're going to talk about ethics, something that we all should know, and I think we all do know, but it's important that we have a time to refresh. And to present tonight is Deborah. She's well known to all of you. She's the principal of her own firm, GA Family Lawyers. She's the immediate past president of our Fine Association, and she's a member of the Family Law Section of the Law Council. And I welcome Deborah.
Good night, everybody. I'm just going to go through, it's going to be a fairly interactive session, which might be a bit scary, but I'll tell you what the answers are at the end. What I want to talk about is to try and make it a practical-based session so that we can have some discussion about some issues that we would commonly encounter in specifically family law, and talk through some of those and refer you to different resources that you might be able to access if you do come across these problems. So that's just an overview of a couple of things that I thought stuck out that we may come into contact with on a regular basis. And I'm going to talk to you about tools that we can access that can assist us with ethical problems. The difficulty with ethical problems is that you can talk to 5 different people and they can give you 5 different opinions as to what should happen in a particular circumstance. So I find it helpful to look at the Australian Solicitors Conduct Rules, which have recently been adopted and in Queensland on the 1st of June 2012. They're also adopted in South Australia. They may be adopted in New South Wales and Victoria, but obviously they're still going through the motions of whether they're going to try and have a uniform profession. Now, there's a link at the back of this PowerPoint which can be accessed from our website after tonight, and I think that's where it'll be on the website. So there's a link to the Australian Solicitors Conduct Rules. They're up on the Queensland Law Society website, so it provides you the link there. The purpose of them is to provide assistance to solicitors to act ethically and in accordance with the principles of professional conduct. They're a guide, so you can't breach the rules. They're there as a guide only, but obviously they would be referred to in situations where someone was assessing whether you had been unprofessional. They include a lot of general principles that we're all familiar with, the duty to the court being the paramount duty for solicitors to uphold, duty to the client, confidentiality, and solicitors not deceiving or knowingly or recklessly misleading the court. So those are some of the general principles that are reiterated in the Australian Solicitors Conduct Rules. They're actually quite easy to read. They're new plain English, so I recommend that you have a look at those on the link. By way of an example, one situation that I think we've probably all encountered in family law is children becoming inappropriately involved in proceedings. So just there, I wanted people to have a look at different ways that you can handle that sort of situation, where a client comes in and you can tell straight away from talking to them that they are being inappropriate with the children, they're getting the children to write statements, they're getting the kids to do recordings, things like that. There is ways that you can deal with that aren't so in your face with the client. Obviously, you have your duty to advise the client appropriately, but you can refer to different things like the family law rules, the obligations and the prescribed information that we're required to give clients under the Act and the rules. Section 12B of the Family Law Act sets out the prescribed information that we need to make sure clients are aware of. We have to make sure clients are aware of the best interest principle in relation to children. So that's obviously a good opportunity for you to come back to those legal principles, and it's easier to talk in terms of what you're required to do legally when you're explaining an issue that is quite touchy subject with a client. There's obligations under Section 12E of the Family Law Act on advisors to advise clients of the legal and possible social effects of the proposed proceedings on children. So again, that gives you an opening to have that discussion with your client about their behaviour and your obligations as a legal advisor to let them know the possible effects of that on their children. And there's also the opportunity, obviously, to refer them to support services such as counselling, child psychologists, so that they do become aware of the damaging nature of their behaviour. Something that comes a similar sort of vein, I'm sure you've all been asked previously, I want to bring my daughter, son in, and I want you to talk to them. I want them to tell you what they want. I would suggest that you would never allow yourself to get into that situation. When you're representing a client, you're acting for the client. Obviously there are circumstances where you can make applications under the Act for a child to be directly represented, but from an ethical point of view you need to make sure you don't cross that line. You're there for your client, and if there is a situation where the children are wanting to have a say, you have to assess that very carefully. Again, going back to the principles under the Family Law Act and your obligations as a legal advisor to let them know that really it may have a significant impact on the children to effectively do what they're asking to do, and that is speak to a lawyer. So, as I said, just wanting to reiterate, it's often a good starting point to go back to the actual Family Law Act and have a look at what your obligations are, and that helps, again, serves as a bit of guidance as to what to do. And obviously in that situation you'd be referring, you'd be talking to your clients about the appropriateness of referring the children to a counsellor or a psychologist if they are expressing some, some wishes to want to be involved in the proceedings. That, as we all know, could stem from lots of different things that they may need to get professional assistance about. Again, coming back to that general best interest of children paramountcy principle. Another situation that we have probably encountered is where you have a client come into your office and they make a disclosure to you which suggests that the children might be at harm. Now that may be them disclosing their own behaviour that causes you to have concern that the children might be at risk of harm in their care. A couple of different issues arise from an ethical point of view there. You have an obligation obviously to your client to maintain client confidentiality, but there are exceptions, and those exceptions are set out under the Solicitor's Conduct Rule at 9.2. One of the exceptions being that you're compelled by law to disclose. At the back of this presentation there is a link to a table which has been prepared which sets out the different child protection legislation between all of the different states and also under the Family Law Act. That's a really good table. In the Commonwealth jurisdiction, we don't have an obligation as a legal advisor to make a notification if we become aware of information that suggests that a child is at harm or risk of harm. But if you're acting as an independent children's lawyer under the Family Law Act, you do have that obligation to make a notification. If you're in the Northern Territory, everybody, it's expressed in those terms, everybody has an obligation to make a notification if they know a child is at risk of harm. So if you were practicing there, then obviously that obligation would fall upon you if you became aware of that information. And I've just referred to the section of the Family Law Act which applies to the independent children's lawyer and imposes upon them that obligation to make a notification. Another one that you may not think initially causes an ethical dilemma is when you're asked to give a second opinion on behalf of a client who's already engaged another lawyer to act on their behalf. It may be that court proceedings are on foot. It may be before court proceedings are instituted. This is a situation where I would suggest it's entirely a matter of choice as to how you deal with this matter. Some of the things that arise is there is duties under the Australian Solicitors Conduct Rule that you would not communicate with a client who is represented by another legal representative. The conduct rules actually provide for an exception in respect of giving a second opinion. But again, as a lot of things with ethics, you may approach that different ways. Some people may feel more comfortable in notifying the lawyer who is actually acting for the party that they have been asked to provide that second opinion. But your duty to the client and your duty to maintain confidentiality would prevent you from doing that unless the client had specifically consented to you approaching that lawyer. Again, there are situations where some people may not feel comfortable and may say, unless you provide that consent to me to discuss it with your existing lawyer that I'm going to be giving a second opinion, I'm not prepared to accept your instructions unless you do that. So again, just some things to keep in mind there. Ex parte application. So you've been given instructions by a client to seek a recovery order in circumstances where a child has been taken by the other parent. The Australian Solicitors Conduct Rule at 3.1 applies in respect of the duty to the court and administration of justice being paramount. You get extra guidance with specifically Rule 19.4, which sets out the information that you really are compelled, underlying your duty to the court, to advise the court of information that's in your knowledge, to make sure the court is aware of that. That really arises from, you're really asking for exceptional relief when you are bringing an ex parte application before the court. You're asking the court to make a decision based on one side of the story, and therefore there are greater ethical considerations when you're preparing the material in bringing an ex parte application. There's also guidance found in the family law rules in relation to ex parte applications. So again, this is really to give you some tools if you come across these situations, just knowing where to look. Because a lot of us have that feeling we know what the right thing to do is, but these are just pointing you to the right tools to access in particular circumstances. Another one which again may not initially raise an ethical consideration is when you're agreeing with a client to act on a speculative or deferred fee arrangement. There does arise a potential conflict of interest in that situation. You have specifically at Rule 12.1 of the Australian Solicitors Conduct Rules, a solicitor must not act for a client where there's a conflict between the duty to serve the best interests of the client and the interests of the solicitor. So if you think through that situation, potentially there is that conflict that arises when you're acting for a client, they're not accepting your advice, you're recommending a settlement proposal which you know is within the range of a reasonable proposal, and your client is not prepared to accept that. Your fees may have run up to a point where you know if they're not going to accept that settlement proposal that their ongoing fees may have the potential to be greater than what their ultimate property settlement entitlement may be. So in that circumstance, obviously what is important is the disclosure that you give to your client before you enter into that arrangement. You need to make them aware that there is that potential for a conflict of interest in the future, and they need to be fully informed about that before they enter into that arrangement with you. I was just going to talk about some specific issues with some technological applications that we now have, and just use some examples as to issues that may arise. Facebook, we have all been in a situation where we've had printouts of Facebook pages and conversations that are on Facebook, and people want to include that as evidence before the court. There is an actual case which took place in the United States of America, where there was a sanction against an attorney in the United States when he actually provided advice to his client to clean up his Facebook account, and that advice being given after receiving a request for discovery relating to the Facebook page. In fact, the attorney went even further to suggest that he should deactivate the account and pretend he never had one. Obviously, it's something that you may just innocently say to a client, you know, make sure that your Facebook account is decent and it doesn't offend. You know, that would be sort of standard advice that you would be giving to a client. But what is to be remembered is Facebook and what is on Facebook is still subject to disclosure. It still falls within the client's obligation to make disclosure of information that may be relevant. So you can't go as far as telling a client that they need to clean up their Facebook page, because what they're actually doing is destroying documents that are in their possession that are subject to the obligations of disclosure. So just something that may not immediately jump to mind, you need to be aware of. Twitter and blogging. A lot of law firms now do have Facebook accounts, Twitter accounts, and blogs, and maybe making comments about what they've done in court on a particular day, referring to particular cases, not by name, but just referring to a particular case. You need to be mindful, even when you're doing that, as to whether you are offending Rule 28.1 of the Australian Solicitors Conduct Rules. That's a very broad principle, but by way of an example as to what you need to think about, if you made a post on Twitter, for instance, I was up at court, I had to wait 5 hours, it's a shambles up there, sorry, I'll just go to the next. That would be offending Rule 5.1 of the Australian Solicitors Conduct Rule. That rule provides that a solicitor must not engage in conduct which is likely to a material degree to be prejudicial to or diminish the public confidence in the administration of justice. So you can see where that would arise. If you're making a statement that is criticising the court system which is in place to ensure that the administration of justice is happening, you potentially, or not potentially, I would say you are breaching that rule of the Solicitors Conduct Rules. So something that might seem like letting off steam and pretty innocent, at the end of a frustrating day at court could technically breach that rule. So something to keep in mind. Just coming back to the issue about Facebook again and gathering evidence. Obviously, there is sometimes valuable evidence on a Facebook page which you would want to be relying upon in court. In just looking at the tools that you can access in relation to ethical issues, there's a link there which will be on our website to the New York State Bar Association. They have a very good system there where you can actually, as a lawyer, obviously we can't, but if you're in the New York Bar Association, you can write in and seek an opinion in respect of a specific issue. So somebody has actually written in and requested advice about the principles, the ethical dilemmas that may arise in relation to accessing Facebook pages and then producing that evidence in court. In that opinion indicated that it would not be appropriate for a lawyer, if you're acting for the wife, to then seek to friend the husband or the other side on Facebook for the sole purpose of looking at their Facebook page to see if there's any incriminating evidence on there that you could rely upon. It's because that would be misleading and deceptive really from a lawyer's point of view. You're doing it for a specific purpose. So they specifically say there's no issue with relying on the Facebook evidence, except if you engage in that misleading, deceptive conduct, for instance, created a false identity another Facebook page and sought to befriend them for the sole purpose of getting that information. And you can't get a staff member to do it either, so you can't direct your secretary to go and befriend somebody on Facebook to get that information. Why would you bother with the Facebook information? This is really, these cases are just there for examples of when Facebook evidence has been extremely helpful in particular cases. Both of those cases were in respect of the Hague Convention, and by looking at Facebook evidence they were able to produce evidence of postings made about parties' intentions at the time that they departed a particular country. So with Hague, where it is such a strict looking at that type of evidence, it can be extremely valuable. Again, another one just by way of example where Facebook evidence was used to great advantage, and that was in respect of a father showing that he hadn't complied with conditions for supervision and was supposed to be at his home, and there was photos on Facebook of, I think, him at the beach. So as simple as that. Another one where it was used in contravention proceedings is there was an entry made by a mother on her Facebook site saying, I was worried for a while there, he wouldn't turn up, but he was running late, I don't care, I still got my babies. Felt like being a smart ass and telling him to be afraid that I won't take them back for another 6 months, which would equal another $20,000. And then the LOL and the other, whatever all that means. That evidence was relied upon by the judge in that case in respect of a recovery order application, and it was relied on in relation to conduct to get a cost order in relation to the mother. So again, I'm sure we all do it now anyway, the importance of advising clients of making sure that they're not making inappropriate postings on Facebook, sending inappropriate text messages, and doing whatever else you can with social media these days. Another good example was the father, in this case, the father had been asserting he no longer had a gambling addiction, and there was a photo of him on Facebook with chips in front of him and the post saying, robbing Star Casino. Just in the similar sort of vein, text messages and emails. Again, we've all had to trawl through hundreds of pages of transcripts of emails or text messages. Just keep in mind Rule 19 of the Australian Solicitors Conduct Rules. Solicitor not deceiving or knowingly misleading the court. So in that circumstance, you just think, we've all read affidavits where there is a transcript of text messages and it's one-sided. It doesn't include the responses to the text messages. I would suggest that there is potential by doing that, by just including one side, there is potential that you could be misleading the court by not providing the full context of the conversation. Okay, now to some interactive hypothetical situations. I'm going to see if anyone's brave enough to give their views about particular things. So this first one, if we're just looking at a situation where your opponent in a hearing before the... I prepared this a little earlier. Before a federal circuit judge in submissions refers to your client having completed a parenting orders program when you know that's not the case. It's your turn next to make submissions. So in those circumstances, you would feel obligated to stand up and correct what had been said by the opposition counsel. So a lot of you would. Looking to try and get some guidance from some of the Australian Solicitors Conduct Rules, you look there, the two specific rules that would apply. Rule 19.2 obliges the solicitor to take all necessary steps to correct any misleading statements made by the solicitor to the court, so made by yourself to the court. You definitely have an obligation to correct anything that you've misstated. But down at Rule 19.3, it makes that distinction that a solicitor does not have, will not have made a misleading statement to the court simply by failing to correct an error in a statement made by an opponent. Again, it comes back to that difference in opinion on ethical matters, and it's really, I think you need to go with your gut feeling in a particular situation, and depending upon the seriousness of the misstatement, of course, and whether it has potential to really impact on the outcome of proceedings. It may be that a statement about a parenting course is not going to have any impact, but again, it's something that you're going to have to exercise your judgment in a particular situation. Looking at another one, so this is in a situation where you've received instructions to file an urgent application seeking a recovery order for a 3-month-old child. You're acting for the mother, she's breastfeeding, you've previously written to the father seeking the voluntary return of the child, and the father sent you an email setting out a list of things that's wrong with the mother and why he isn't returning the child. And if some of those things in that email were proven to be correct, there would be some concerns about the mother's parenting of the child. In those circumstances, who would bring that email to the attention of the court? So not many people would bring it to the attention of the court. In that situation, the important things to consider is you're seeking an urgent application for a recovery order. So potentially it's an ex parte application. If it is an ex parte application, would that change people's view about whether they should bring that to the attention of the court? Yes, I'm seeing most people nodding. That probably is the important situation. Obviously, if the father's there, he's able to express whatever he wants to. But in an ex parte situation, you would be, I think, under Rule 19.4 obligated to ensure that the court had access to that material. Okay, moving on to another one. You have a client telling you that they're not going to comply with a parenting order which provides for a child to live with the other parent. Sorry, I think I said that. Yes, the child lives with the other parent, and your client's going to keep the child and not return the child contrary to the order. Now, I'm sure we've all had situations where we have acted for people in this situation. Does anyone want to have a go at expressing what they would do in this situation? I won't nominate anyone. Well, yeah.
I talked to them about the definitions plural of reasonable excuse, and I'd probably wind up advising them that if they intend to do that we will make an application straight away.
Oh. So, are you doing it on the basis?
If it's excuse, I tell them to send the child back, or I can see it back to.
So that would be one of the options available to you. If, again, you get some guidance from the Australian Solicitors Conduct Rules at Rule 20.3, it specifically provides a solicitor whose client informs the solicitor that the client intends to disobey a court's order must advise the client about and warn them of the dangers of doing that. So that would encompass that response, telling them about a contravention application being a likely result of their action, talking to them about the defences available, at seeing really whether they could make out such a defence. And you are obligated under the Australian Solicitors Conduct Rule to advise the client not to carry out that action. So that would be on the basis that you would tell them about the correct way that they needed to approach the matter, file an application, do it through using the system in the proper way. Would, again, that raises a situation for you if you become aware of this information from your own client that they're not going to comply with an order? Do you have any obligation to notify the other solicitor or the other party that a potential breach of order is going to take place? Again, that raises some conflicting duties that you have. You still have the duty to your client. You have the duty to maintain confidentiality in respect of your dealings with your client. And specifically at in Rule 20.3, it provides that you would not inform the court or opponent of the client's intention unless certain things had occurred. Firstly, whether the client had authorised you to do that, well, that's unlikely. If they're going to breach an order, they're unlikely to give you consent to inform the other party that that's going to occur. Or you believe on reasonable ground that the client's conduct constitutes a threat to any person's safety. So again, it comes down to the context of the situation. If your client in that situation is saying, I'm going to go to the school and I'm going to get that child no matter how I get them, and I'm going to, I'm going to take a gun, or obviously that would fall within that exception, and you would have to make a judgment call as to whether your duty to the client was overridden by the need to warn the other party to prevent danger happening to prevent the child being in a dangerous situation. Okay, here's another hypothetical. You've got a client coming to you as a new client, and she talks to you about her fears that the father is going to sexually abuse her child because the father was involved in a sexual relationship with his sister when he was 15 and his sister was 13. So that's the information she's basing her fear on, that the father has had an inappropriate sexual relationship with his sister when he was a child as well. She wants to commence a parenting application seeking supervised time only. Does that raise any ethical issues for anyone in that situation, or do people just think that's a standard type of situation and you'd advise a client as you would in any other? What I think some of the things that you would need to look at, again, going back to the Australian Solicitors Conduct Rules, looking at Rule 21.2, a solicitor must take care to ensure that decisions by the solicitor to make allegations or suggestions under privilege against any person are reasonably justified by the material available to the solicitor. So that really, these ethical obligations assist us, I suppose, in best practice with family law as well, because you're really testing your client as to this is a very serious allegation that you're making. You're going to appear in front of a court and you're going to be required to justify why you are making this allegation. So again, it's that talking through with a client whether their position is a reasonable one, how a court may potentially interpret their position. You would have obligations to ensure that your client, if the court didn't believe them, to make them aware of the potential disastrous effects to them, as including the potential to lose residency of the child. So with the Australian Solicitors Conduct Rules, I found just by reading through them all of these different factual scenarios sort of come to mind, and they're a really good guide just to have a quick look through. Okay, and another hypothetical, I don't know if anyone's been in this situation. I don't think I've actually seen an assault, but you're up at the court and you're there with your client, and your client's former partner walks over and assaults your client right in front of you. So you've witnessed an assault happening right in front of you. In that circumstance, would anyone have difficulty in continuing to act for their client? No one's indicating any difficulty. What if your client had alleged that her former partner was extremely violent to her that she was a victim of domestic violence, that part of her case was to establish that her client, that her former partner was a violent man and the children were at risk. Would that cause anyone to have just a niggling concern about whether they could continue to act for the client who had been assaulted?
It would be difficult for me to go to then be a witness in that matter.
Yeah, so that's the potential of conflict that arises for you in that circumstance. It may seem unfair. You've witnessed something, but you have to consider, does that now raise a conflict of interest in relation to me continuing to act for the client and my duty to the court when I'm a witness in the matter? So again, looking at Rule 27 of the Australian Solicitors Conduct Rules, that can provide some guidance there. It specifically provides in a situation where it becomes apparent that a solicitor will be required to give evidence that's material to the determination of a contested issue before the court, the solicitor may not appear as advocate for the client in the hearing. So it does make a distinction. It's saying you can't appear as the advocate. So if a barrister witnessed the assault happening and the issue was material to an issue that had to be determined by the court, under the Australian Solicitors Conduct Rule, they would have some difficulty in continuing to act as the advocate in court. And again, the reasoning behind that, it comes down to the prejudice to the administration of justice in the conflict of your duty to your client and your duty to provide the evidence to the court. Yes. Yeah, so you see the difficulty that arises there. Was he seeking to give evidence about it?
The good news is if the barrister and the solicitor witness the assault, then the client can call the solicitor to give evidence about the assault.
Potentially, because it doesn't breach the Australian Solicitors Conduct Rule because the solicitor is not going to be the advocate appearing in court. But again, it's still something that you need to think about, whether it still does raise an issue of conflict. You know, what if the solicitor actually saw your client goading or throw the first punch or something like that? Then they have a duty to give the evidence as they saw it when it's really detrimental to their client's case. So you have to consider all of those things at the time. Oh, I've got another one. I think this is the last hypothetical. This is a situation where a client comes into your office, they're an existing client, and they provide you with a copy of a letter of advice. It's a letter from Hopgood Gannon and it sets out 20 pages of advice addressed to your client's former partner. And your client tells you they printed it out from an email account of their former partners that they can still access. So if that happened, who would read the letter? Oh, you're better. I talked in Melbourne and 50% of the audience put up their hand and said they would read the letter. So it's good to see Queensland practitioners wouldn't. If you
don't you know if your client's actually telling you what is, the daily basis for their assertion that this is an email from Hopgood and Gannon, or?
Yeah, that's exactly right.
Like just looking at a contested piece of evidence and looking at it to see whether or not it should be admitted, you know?
Yeah, so that's correct. Yes.
On that, where the client comes in and says, my ex-husband's given this to me, and, you know, to show you how good Hopgood Gannon are and where you are. What's the ethical situation there?
Well, in that situation,
way of legal privilege.
yeah, the difficulty is if they get it from dishonest means, like accessing an email account that is not their own, then it's a breach of client confidentiality. But if the partner actually hands them the letter, they are waiving their confidentiality, and there wouldn't be an issue. If you look at Rule 31 of the Australian Solicitors Conduct Rules, it does, it provides some specific, quite direct guidance in relation to it. So if you come into possession of material which you reasonably suspect to be confidential, and you're aware that the disclosure was inadvertent, you must not use the material. That's what the rule specifically provides. You must return, destroy and delete the material immediately upon becoming aware that the disclosure was inadvertent. So there's still some grey area there. You may have a situation where a client just hands it to you and they don't give a clear explanation as to where they got it from. And you would be obliged in those circumstances to clarify with the client how they got the information to ensure whether it was through an inadvertent disclosure of it when it was intended to be confidential. Again, I would suggest that you would have to notify the other solicitor immediately and tell them, I've received this email, I don't think it's for me. You wouldn't read it. You'd look at it enough to identify that it's really not intended for you, and you should destroy it and return it and notify them immediately. A further dilemma that may arise is your client may bring that in, hand it to you, and you're going to give them the advice, look, I can't read this, I've got to tell the other solicitor that I've got it, and they specifically instruct you, no, I forbid, I do not authorise you to notify the other side that I have got this correspondence. So again, that puts you in a situation of conflict again. You have, again, your overriding duty to the court, really, which is paramount to any other duty, including the client, and you would have to consider in that situation that you potentially would still have to comply with Rule 31 of the Australian Solicitors Conduct Rules, and in those circumstances you may not be able to act for your client any further. It provides specifically at 31.3 that if you're instructed by a client to read it when it's received in error, you must refuse to do so. I think that's the end of the hypotheticals. And just at the end, again, you'll be able to access this on the website to get some useful links. Found our Queensland Law Society has a very good section on our website, an specific ethics section. It has the ability for you to ask questions of the ethics officer at the Queensland Law Society. It's a great service, and certainly it's always good to talk through an issue like that with somebody else. There's also the other law societies, New South Wales, Law Institute of Victoria, have some helpful information on their website as well. Particularly, the Law Institute of Victoria has a specific guideline of the use of social media. And that's what I was referring to before, that link in respect of mandatory obligations to make notifications in child safety matters, and that's a specific link for the Law Society. So that brings to an end the talk that I wanted to do tonight. Does anyone have any questions or any matters that they wanted to raise?
I think those on the webinar can type a question if they want to.
But maybe you can type that question into the Queensland Law Society Ethics Office and they can assist you with it as well. Well, thank you very much for listening. I hope you got something out of that. Again, just wanting to reiterate that you can get different answers in respect of different scenarios. There's no black and white answer, unfortunately, that's It's what's called ethics. You have to exercise your own judgment, and hopefully you can use some of these tools and guidelines if you do come across a situation which raises these issues. Thank you.